The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 22nd of June, 2016, are currently trading with gold at $1,265.56 an ounce, silver $17.28 an ounce, Texas crude $48.85 a barrel, and Bitcoin dropped to 625 U.S. currency. Today in history, last year, 2015, South Carolina Governor Nikki Haley calls for the removal of the Confederate flag from the State House grounds in the wake of the senseless killings in a Charleston historic church. It was this event which led to the nationwide ban on the Confederate Dixie flag. Today in history. In recent news, House Democrats had a sit-down on the floor of the House chamber today. They effectively forced the House into a temporary recess as part of an effort to get Republicans to vote on gun control legislation. Representative John Lewis, Democrat from Georgia, a civil rights leader who led sit-ins all throughout the 1960s, led the effort with sharp criticisms towards Congress for not voting in favor to pass more gun restrictions. Democrats are planning to essentially hijack the House floor both Wednesday and Thursday in an effort to get gun control measures a hearing. A spokeswoman for Representative Speaker of the House Paul Ryan, Ashley Strong, said that, quote, the House cannot operate without members following the rules of the institution, so the House has recess subject to the call of the chair. As a minority party, Democrats have virtually no power over which bills are voted on. The only thing they can do is protest or use procedural maneuvers, of which they plan to do both this week, so keep your eyes on the House floor. Ultimately, the goal is to force lawmakers to vote on a bipartisan bill that would give the FBI and Attorney General the power to ban people on the controversial no-fly list from purchasing firearms. According to a government report by the Treasury Department released today, the trust fund used to pay hospital insurance costs for Medicare will be emptied out by 2028, about 2 years earlier than calculated, while the Social Security Trust Fund has enough cash to pay full benefits for only another 18 years. The trustees overseeing both stated that reforms are needed in order to avoid cutting health care and retirement benefits for Americans. Acting Commissioner of the Social Security Administration, Carolyn Colvin, said that increasing payroll taxes by slightly more than 1% could improve the solvency of the fund over the next 75 years. Maybe it's time we start looking for and creating options that don't involve Uncle Sam. This is Rick Rohde with your lowdown for June 22nd, 2016.
My remedy today.
Okay, we are back. Randy Kelton, Vet Pack, Rule of Law Radio, and Oliver, you know, every time I talk to you, your questions and comments get more sophisticated. And that pleases me greatly. And this is the most sophisticated so far. And for those who don't know, let me kind of give some perspective. Oliver went to the city after they tore down his building and asked him under what authority they did this, and they gave him authority that went to, what was it, commercial, Oliver?
Residential Building and Maintenance Code.
Yeah, and how did that not apply to you?
It did not apply to me because residential meant commercial and housing enterprises, which means that these are companies or people who make more than 80% of their income through renting property for people to reside in.
Okay, so this didn't go to a consumer. It went to a commercial. You're a consumer because you consume the property by living inside it. And even if this is a second house, if you purchased that house for the purpose of living in it and then bought another one and rented this one out, that's still residential. It's not commercial. So you're telling them that the law they relied on only applied to commercial properties and did not apply to residential property. So now, how does that apply? How does this comity issue apply to that?
Well, the thing is, their code only deals with public facilities, public property, public residential places like hotels, apartment complexes. People who are saying those are residents. People who own property and live there, those are not residents. Those are inhabitants. They inhabit this area. Even if they leave the state, they are still considered to be here. So
okay, this is where your habitation is, as opposed to you're just residing in the area temporarily.
Right. So But they have authority over those properties because the public is not allowed access to that property, so they cannot claim that they are doing something for public health or public regulation. That's private property.
That is interesting. That's a way of looking at this that I haven't heard before and haven't examined before, but that absolutely makes sense.
Well, that's what it spells out in the way that their code is written. Once you define all their definitions and then reread their code, you'll see that it is restricting, it is protecting someone's right. It just doesn't clearly say it out loud. But when you go back to the state statutes clearly tells you who they have authority over. And in the building and code maintenance section, it clearly says building contractors and people in maintenance contractors. They are contracted to maintenance the property so people can reside in it. That's a residency. So just if I own property here and I live here, that doesn't mean I'm a resident. They took the words and switched it around on us, so we wouldn't be able to figure it out.
Okay, this is something that Eddie's really good at, and something that we talk about here about how when you're dealing with law, they don't speak English.
Right.
They speak legalese, and Oliver, it sounds like you're getting relatively fluent in legalese.
I am, but now, like, how do I use it? And then I have one block. You told me to go find a legal guy, and I went talked to about 20 presidents, and they tell me they don't have anything. Everything is online through their system or whatnot, and they couldn't provide anything. So I'm kind of getting a block as far as the litigation guide part, but everything else is coming to me fluidly once I've defined the words and get all the codes and which chapters and differentiate how they work. If this falls together, well,
you are beginning to understand one of the most subtle and complex aspects of law, of dealing with law, and that's the word crafting. Lawyers specialize in word crafting, and you are going to become a force for them to reckon with. You've got the idea now, and I'm going to be looking forward to seeing how you stitch these together. Now, as to adjudicating the issues, the way I started doing legal research is I went down to the courthouse and started pulling cases and just went through cases. I asked the clerk for the biggest cases they had. And she said, "You mean the most important?" "No, I mean the biggest, the one that takes up the most boxes, because I want to see the issues that were hard fought." And I looked through those, and I found stuff I would have never dreamed of. This is the first time I ever saw a motion in limine. I pulled this thing out, and a motion in limine, I had no idea what in the world a motion in limine was. A motion in limine is a motion that prevents you're asking the court to direct the other side not to ask certain questions or not to produce certain evidence. And I never thought of anything like that, and I find it in the files. You'll find all kinds of wonderful stuff in the files. If you can go down and find some cases concerning condemnation, concerning demolition of buildings by the city, you're likely to hit on a case close to yours, especially if you can find a case that addresses a wrongful taking of private property. And don't just get the case law. If you find a case that's on point or close to point, then go to the courthouse and get the filings. Go ahead, Dark.
I tried it. The closest thing I could find is a regulatory taking. And with the regulatory taking, it was very minor. They did not allow them to subdivide their plot to rent out to become a residential area like they're supposed to. So they sued them just for telling them no, they can't divide their land up. Mine was a lot worse, and I can't find. That's the closest things I can find to it.
Okay, let's try a little research.
Well, It's the closest thing I can find to it in this county that was from this county, from this state, actually from this city. What is the city? It was county. Yeah, county. It was Montgomery County that they sued.
I did a search for Jackson, Tennessee, city demolished my house. But I didn't get as good a hits as I thought of. If you do some creative research just on a standard search engine, you will be surprised what you will find.
Mm-hmm. Even if it's not from my state, can I still use it? If it's from another state, can I still use it as far as for investigation purposes?
Wait, I couldn't understand that. Can you do what?
Can I still use it if it's from another state? On the search engine, when I find the information, if it's from another state.
You you can, but this goes to property issues. You're definitely going to have law on this issue. What you might... Okay, I would... there's law in Tennessee for this. It's definitely Tennessee law. No doubt about it. This goes to private property, and this is such a common thing that there's going to be law here. It's just a matter of finding. The hardest thing to find in doing legal research is the first case on point. Once you find a case on point, then they will lead you to other cases. Let me try another. I'm looking in Jackson, Tennessee. City improperly demolished my house. Okay, I got one here. Oh, there we go. Up to 400 Jackson homes could be demolished if city receives something. Building housing. City of Jackson County, including towns, major emergency. I'm not finding hits, but there's got to be similar cases. Just
everything that I find it deals with that, but the city done it in a different fashion than they've done it in mine. It's always a blighted area or something different. It's not dealing with personal private property. Okay? It's always dealing with another issue, which it does if you read the case, it does give you some important information as far as the rules of certain aspects, but it doesn't hit it exactly on cue like my situation is.
Go to the district court and talk to the district clerk. Or do you have a law school anywhere nearby? Union City. Do you have a University of Tennessee close to you? I know Union City has one. You need a law librarian.
Mm-hmm.
They're better than lawyers because that's all they do all day is research. Find a university with a law school and call and talk to the librarians. They are incredibly helpful. They will bend over backwards to find you what you need. And I almost guarantee you, you call a law librarian, she'll put you right on what you need.
Okay.
So try that. Any law school that's close. It doesn't. I think UT, University of Tennessee in Union City has a law school. But call around, find one, and ask the law librarian.
I have one more question, and I will make it quick.
Okay, hold on. We got 12 seconds to break. Randy Kelton, Vet Pack, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. The LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. And tell Satan, get behind you. Know what I mean? My friend. And all of your children, come. Those things that hurt me free. Telling your problem.
Okay, we are back. Randy Kelton, Vet Pack, Rule of Law Radio. And we're talking to Oliver in Tennessee. Well, I was trying to do a little research over the break, but like you, I haven't found anything yet.
I know.
So try the law librarian. If anybody can find it, she can. Okay, and you had another question?
Right now, they towed 12 cars from my property, and this tow truck company have it. Now, should I file suit on both of them individually, or how do I do this situation?
You sue them both together. You make them both parties to the suit. Just one suit.
So one suit. So who am I suing?
You sue the city and you sue the towing company.
So it's two parties.
Yes.
So when I'm doing the procedure, just whenever I do the defendant, just provide both their names, the city of Clarksville and the towing company.
Yes, yeah, like City of Jackson and so towing. You just name them both. And then in the body of the suit, you make claims against each of them. You make a claim against the city, claiming that the city illegally authorized the towing of your vehicle and that the towing company improperly entered your property without a proper authority and took your vehicle. So you make accusations against both of them. But you can do it all in one petition.
Right. So the accusations would include the code, the laws that they broke, like the actual numbers.
Yes, exactly.
So I got all that.
You need to tell them what was wrong and why it's wrong. The only purpose, the only job of the trial court, or the primary purpose of the trial court, is to determine the facts in accordance with the rules of evidence, and then apply the law as it comes to him to the facts in the case. So when you write your petition, you tell the court first what the case is about. This case is about the improper demolition of a private residence. The improper taking of private property by the city or by defendants. That automobiles were towed from your private property without proper authority. That kind of tells the court what this is going to be about. And then you put in a section on venue, the jurisdiction and venue. And you can just go look at some cases that's been filed in a court, and the section on jurisdiction and venue will be essentially the same in every one of them. So you just pull that section and drop it in your suit. And then you name the parties. Plaintiff is you, and you give an address, a phone number if you've got it, an email if you have it. And then defendants, you name each defendant and give the address. And now you go to a statement of facts. And in the statement of facts, you only state facts, no conclusions. But when you create the statement of facts, you want to stitch your facts together in a way so that the reader, when he reads the facts, you'll be thinking, okay, why did he put this fact in here? How does it relate to the fact above it? So you construct your facts in a way that the reader will tend to come to the conclusions you're going to want him to come to. It's writing this for a judge, and he pretty well knows the underlying law. So as he reads it, he'll be applying the underlying law to the facts to see how they stitch together. Then a brief in support, a statement of factual accusation, whatever. Now you put in the facts, you apply the law to the facts, you say they did this, this is a law that applies to this, and this is what the law says should have been done, and this is what they actually did. So now you apply the law to the facts. Never make a proactive statement of law out of your own mouth. Never say the law says you can do this, you can't do that. No. Judge can't listen to that. You say the court said in this case you can't do this, you can't do that. Always make your proactive statements of law out of the mouth of the court. That will give your document much more influence and impact because the court will recognize that you're taking this right out of cases. Once you find a case on point, you want to find briefs. Briefs are wonderful because in the briefs, that's exactly what the lawyers do. So if you can find a brief that addresses your issue, then you cut and paste. If you spend much time constructing your own arguments, you haven't done enough research.
No,
you should.
I mean, I found the, as you call them, I didn't know they were called briefs, but I found, like, as I'm reading over these cases, I found a section that clearly dispels out other parameters that could happen to kind of like safeguard, like, okay, since we had this problem, we're going to cover this whole section so you won't come up here again with another issue. So it is not their case, their argument is not about it, but on the brief to the Supreme Court of Tennessee or the appellate court, they'll say something. Not only this, but private property also has this and this and this and this. So you telling me that type of information I could use, even though that case is not exactly like mine.
Right. If the principles apply,
right.
Then you pull out the most important skill you can develop for writing legal documents. You must become an accomplished plagiarist. Okay. Never write it yourself if you can find it in a court decision or in a well-constructed brief or pleading. Steal what the lawyer wrote. It's perfectly fine in law.
Okay, so plagiarism is good in law.
Yeah, you should not perjury, plagiarism.
Plagiarism.
You should spend most of your time stitching other guys' writings together, changing cases so the case sounds right, changing he to she, just stitching these together so they read well. Most of what is in there, you should, if you can, you want it to be put in from a court ruling. Court orders are the best. When a court issues an order, they generally include findings of fact and conclusions at law. If you can find it from court orders saying what you want it to be said, that is the most powerful thing you can use in your document. And when you cut something out of a court order and drop it in your document and just reword it so it fits, the judge will look at that and he will know exactly what you did. And that will give your documents much more import because he knows this is not statements out of your mouth. This is statements out of the mouth of the court. Okay, does that make sense?
Yes, sir. Understood. One more hurdle: the condemnation. I have it on the paper. It said that they went through a condemnation hearing, but what they're trying to say is that this condemnation is different because they did not take the title from me, so they did not have to compensate me.
Wait a minute, I didn't understand that.
They went through a condemnation hearing. Basically, they had to condemn my property in order to knock it down.
Okay.
So
did they have authority to condemn this particular property?
No. But they went through a condemnation procedure to do everything. They went through a condemnation procedure, and everything I find in their codes or statutes, when you see condemnation, that includes compensation. I brought that up. They told me that that's under eminent domain. They didn't do eminent domain on my property because they didn't take the title from me. So I'm like, okay, well, what is this condemnation then? Because I can't find it anywhere else. Everywhere there's condemnation, it says that compensation is automatically attached.
Are they saying that your house wasn't property, only the land was property? Okay, hang on. About to go to break. Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number, 512-646-1984. We'll finish this up on the other side. Doug, Jay, I see you there. We'll get to everybody. We'll be right back.
When creepy crawlies attack your vegetable garden, don't reach for toxic sprays and powders. They can make you and your family sick. I'm Dr. Catherine Albrecht, and I'll be back in a moment with an inexpensive, safe solution for winning the battle of the bugs.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Neem, spelled N-E-E-M, is an oil pressed from the fruits and seeds of an Indian evergreen tree. It's a natural insecticide that can handle even resistant garden pests. Neem is not only effective, it's proven safe. It's been used by the Indian people for thousands of years to ward off insects and fertilize crops. They also use neem tree extracts in traditional medicines, health products, and cooking. You can make your own neem pesticide by mixing half an ounce of organic neem oil, half a teaspoon of liquid soap, and 2 quarts of water. Spray it on plants and flowers to kill a wide variety of insects, including ants, aphids, beetles, and caterpillars. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Backpack Real Law Radio, and we're talking to Oliver in Tennessee. Okay, go ahead, Oliver.
The condemnation part. Okay, they basically, it looked like they try to hide up underneath the eminent domain, but not try to pay out, because condemnation, only way I find condemnation is underneath eminent domain. But they're saying that, well, we didn't go through the eminent domain procedures, so we didn't condemn your house.
So by what authority did they take the house? They did a taking.
Yeah.
Under what authority did they do the taking?
I can't find it. They said that they condemned it. But
Did they say this with their mouth, or did they say this in writing?
I have a paper which has a condemnation hearing date, like from, the documents that they supplied to me that from the situation. I have a physical document where they had a condemnation hearing at the Buildings and Codes office, not a court, not judge, a building director. And I didn't go because you have no authority on me. I'm going to live my life. I'm gone. So they condemned me. The building director condemned my house because I didn't come to the condemnation hearing. Like, I had a contract.
Okay, so the question becomes, where did the building director get authority to hold this particular hearing?
I don't know. But that's what I'm trying to figure, because I'm trying to figure out how do I argue that, because I know that it's complicated, because there is condemnation in there. They're saying that they did not do eminent domain, but condemnation is found nowhere else but eminent domain. I can't even find condemnation in their code, but in their code has eminent domain, and it shows condemnation in it.
Okay, you said that they said they didn't do eminent domain. Did they say that in writing?
No, they didn't say that in writing.
Okay, it doesn't mean anything.
Okay.
Construct something to get them to say it in writing. You might do this with a tort letter. Do you have pre-litigation discovery in Tennessee?
Pre-litigation discovery?
Yes.
Is that something that you file after you file suit?
No, something you file before you file suit. It's really discovery for the purpose of preserving evidence.
I didn't information. Is that what?
Just do a search for pre-litigation discovery in Tennessee. Every state has it in one form or another. And this is a bit complex to do on this show, but you really need to figure out what the issues are, and it appears as though they're pretty clear. They did an improper taking, and it appears that they know they could not do it under eminent domain because it didn't apply to you.
Mm-hmm.
So they're trying to find a way to justify what they did, but where you can't make a proactive statement of law out of your own mouth, neither can they. Anything they say that just is, well, we can do this or we can do that, that's nothing.
So object. As soon as that starts coming out of the mouth, object.
Yeah, object. Now you want to see law, because they're public officials. They may only do what the law specifically authorizes them to do. Ask for that specific authorization, and you might send a request to the person who held this hearing and request the specific authorization under which he held the hearing.
Oh, they already gave me the code. They gave me the code. They gave me the authorization. Nothing in there says that they were condemned. It said abate.
Did they give you that in writing?
I have it. I pulled the document offline.
No. You need them to tell you under what authority they did this. And you need to do that in an information request. You need it out of their mouth. You can't imply what they did it under. You can't go in and say, this is the only thing they could have done it under. You need them to justify what they did.
I mean, it's in writing. I have paperwork that in writing what they did. They spelled out the code, the reason why, authority gave them. I have all the paperwork.
Okay. And you can show that code they acted under didn't apply in this case.
It doesn't say condemned anywhere in the code that in the numbers that they gave, in the citation that they gave. Nowhere in there said condemnation hearing.
So you might ask specifically for the specific authority to hold a condemnation hearing. Be specific, be pedantic.
So basically make them look bad in court.
Make them give you an admission or get them to say something stupid.
Gotcha.
And send them an information request under what authority do you hold a condemnation hearing on a private residence. And what they send you becomes collateral estoppel. They're stuck with it.
So can I send that? Can I sneak that in the tort letter to the city and to the...
No. Put that in an information request.
Information request. Okay.
Yeah, before you do the tort letter, send them an information request and ask for that.
I see. Okay.
They won't be near as careful if you haven't sued them yet.
Gotcha.
And they're likely to do something stupid and give you something you can really hammer them with. Okay, I do need to move along. I got a full board of callers, and I'm going to run out of time here.
All right.
Okay, thanks a lot, Oliver, and keep us up to speed. Okay, now we're going to go to Megan in Illinois. Doug, Jay, I'm sorry I'm jumping over you, but Megan's a first-time caller, and we tend to take first-time callers first. I hope you don't get upset at me, but we'll get to all of you. Hello, Megan. What do you have for us today? Megan, are you there?
Yes, I'm here. I'm sorry, I had the phone on mute. A friend referred me to you. I had my house completely foreclosed on in December 2014. I had a 1099 issued to myself and my ex-husband for the full amount of the judgment, because we did have an ad personam judgment put against us in the final paperwork. And we talked about the 1099 on our taxes, so we assumed that it was all done and over with. An attorney that had been advising me had said, you're either going to look for the 1099 or look for like a lawsuit. And so just last week, a letter came in the mail from Dick O'Neill in Dallas, Texas, saying that I owe personally, never mind anything about my ex-husband, $135,000 in a deficiency judgment. So I'm in the 30-day window where they're giving me the opportunity to dispute the validity of the debt. And I've been talking to different lawyers around Chicago, trying to find someone that would help me fight it. But it seems like everybody is so used to this happening now that, say, for example, like a real estate attorney would talk about, okay, we can either do the Chapter 13 bankruptcy, we can try to negotiate the amount, or you just pay back the whole amount, however long it's going to take.
Okay. Did you resist the foreclosure?
No.
Okay. Probably the most effective thing you can do, and these are not things lawyers should do because lawyers live in a different house than I do. I'm not dangling by my bar card. So I think differently. Probably the best thing to do is a collateral attack. Go back and pull all the documents filed in the public record. Hang on, about to go to break. Randy Kelton, Vetpac Wheelwell Radio. We'll be right back. Okay, we are back. Randy Kelton, Vetpac Wheelwell Radio, and we're talking to Megan in Illinois. Okay, why did you not challenge the foreclosure?
Well, it initiated with a divorce, which wrapped up in 2013. So I had already left the house. My husband, who hadn't done anything with the divorce, was pretty much just sitting around, not doing anything with life, was the one sitting in the house for free. We had put ourselves probably in $50,000 worth of debt at that point, so it's not even like I had any accessible money to pay a lawyer to do anything for me. So,
okay, that makes sense. Okay.
So I didn't want to extend letting him live there for another year or two free. I wanted to be broken from him completely.
Oh, okay.
The lawyer who I consulted with had told me that it was possible that even if I could pay a lawyer $10,000 to do a foreclosure defense, it could still result in the same boat that I'm in right now, that at that point, deficiency judgments weren't really being chased yet. So it was sort of like a wait-and-see game. And even if I had a foreclosure attorney, they couldn't have guaranteed me at that end result that someone eventually wasn't going to come after me anyways.
Okay, nobody can guarantee you anything because the courts are arbitrary and capricious. And that's why I suggest to most people that you try to deal with the other side. And first thing we do is try to get as much leverage as we can. Now, what I suggest you do is look in the public record and find a problem with the foreclosure, and there are always problems with the foreclosure. And then file a wrongful foreclosure action. And that's going to stop everything. That's going to stop them coming after the deficiency judgment. You hope that they've sold the property to a third party. It's once you file the wrongful foreclosure suit, then you file a less pendants in the public record on the property. And if a third party's bought it, they're going to go ballistic. But they can't do anything to you. They'll have to go back to whoever sold it to them. And the third party purchaser is likely to sue the seller. Then you go to them and say, guys, let's make a deal. You drop the deficiency, I drop my suit.
So who can help me with this around here? Because everyone that I try to contact wants me to just roll over and die and file a Chapter 13 like that.
Okay. Look online for Fraud Stoppers. He's in Chicago. Frank Waldo is in Chicago, and what he will do is refer you back to me, and I can help you with this.
Okay, that was great.
I will teach you how to be the pro se from hell. You, as a private citizen, have powers and abilities far beyond those of mortal attorneys. We will show you how to make them crazy. But for the most part, you have no idea how powerful you are. And the thing we will help demonstrate is that when you walk into a courthouse, the judge, the bailiff, the clerk, the lawyers, they're all public officials. Lawyers are quasi-public officials. They're all essentially public servants. They're the servants. You're the master. And once we show you how to do it, they better not ever forget that, because you can wind their clocks, especially the judge. You can wind his clock, and there's not anything he can do about it. He's used to dealing with lawyers who come in there dangling by their bar card. He can jerk their bar card on a whim. So he's used to lawyers kowtowing to him and dodging around him because they don't want him upset at him at all. I don't care if that judge is upset with me. First time I get a bad attitude out of the judge, I'm going to be right down his throat. Say, you are here to determine the facts in accordance with the rules of evidence and apply the law as it comes to you, the facts in the case. If you have yourself another agenda, you need to get yourself down off that bench. And I have done that to a number of judges. And it always gets them to back up. They're thinking, what can I do to this guy? Nothing. What can he do to me? He can crucify me.
Well,
the main thing you want to be able to do is simply give the other side enough grief that they will want to make a deal with you to get you to go away. Whatever that deficiency judgment is, you can cost them a whole lot more than that. And depending on what I see in the record, the first thing I want to do is look at everything that's been filed in the public record. I spoke earlier about how the banks in 1995 created MERS because they had this investment strategy, this scheme for using residential mortgages as an investment package. You got long-term investments in retirement plans, and you got long-term indebtedness in residential mortgages. This is a perfect combination. You sell the mortgages to the investment plan. It's perfect marriage. Problem. Residential real estate has filing requirements that make this impossible to do legally. So they come up with a scheme to try to do it in a way that looked legal, but it wasn't. And now their scheme is falling apart. And because they ran this scheme, there were fundamental problems that caused them to screw up everything. Every time I look through the records, I find so much garbage You wouldn't believe the garbage I find in these things.
Well, in 2006, we mortgaged 100%. We didn't even really have verification of Jeff's employment, and they still gave us the loan. Another thing that someone had mentioned was perhaps the angle that the broker...
Okay, we just got a case out of the U.S. Justice Department with JP Morgan Chase and I think Bank of America. They were suing them over a bunch of mortgages, and they're trying to figure out who actually held the mortgage. And in the decision, the court said that the Justice Department, with all of its resources and its thousands of employees, could not figure out who actually owned the mortgage. Nobody, not the banks, not the servicers, nobody can figure out who actually owns these mortgages. This is from the federal government. So you got this guy coming here saying, oh, I hold this mortgage. Okay. Show me how you got it, Bubba. They cannot do it. Just cannot.
Right this minute, since I only have a little less than 2 weeks before my 30-day window is up, that I should have...
Don't worry about your 30-day window. But we can get something in. We'll file a quiet title against the deed of trust. And then file a les pendants that stops all this clocks. So send me an email or just write down Fraud Stoppers and then do a search for Fraud Stoppers and contact Frank, and then Frank can help me because you're in Chicago and I'm in Texas. So I can help you because I'm familiar with Chicago. I grew up on the near north side.
Okay.
Great neighborhood.
Right. So that would be
north and western. Normal humans won't walk in that neighborhood. But anyway, get a hold of Frank. Frank will get a hold of me. And first thing I'll want to do is a complete analysis of all the documentation filed in the public record. And from that, I'll have claims coming out your ears that you can make against them.
Excellent.
And then we go after it.
A friend has brought up things like the fair debt collection practices, if that applies, or if perhaps
we're not even going to get there. FDCPA, we won't even get there. What we want to do initially is stay with contractual issues. You go to FDCPA, first thing they're going to do is remove to the federal court. The other side is going to file a Rule 12 motion to dismiss. The judge is going to dismiss with prejudice because the federal courts are bought and paid for. The banks own them. So what we want to do is keep it in the state court. They don't own all the state judges. It's not saying the state judges aren't as corrupt as the federal judges. It's just the banks don't own all of them. And they're more politically sensitive. And we know how to generate politics. Well, if you listen to the show regular, we'll explain how we do all of this. You know, one thing to understand, you will never win your case simply because you have the law and the facts on your side. To think so is naive. You will only win the case if you have the politics on your side. And all politics is local. We will show you how to generate lots of politics. When you start kicking that judge in his professional behind, he can't say anything to you, but he can go grab that lawyer by his throat and tell that lawyer, you better get this woman off of me or I'm going to kick your behind. This is how we generate politics. We generate pressure from the judge. We generate pressure from the banks on these lawyers to come to the table and make a deal and make all this go away. Okay.
Well, thank you so much for talking to me, and I'll email you.
Okay. Contact Frank Waldo at Fraud Stoppers, and he'll get us together, and we'll get you something worked out. 2 weeks is plenty of time to get something in and get these guys backed up.
Okay. Thanks so much.
Okay.
Bye-bye.
Thank you, Megan. Okay. We're about to go to break. When we come back, we're going to go to Doug in Ohio, and then Jay from Georgia. We'll get to both of you. We'll be right back. Okay, we are back. Randy Kelton, Vet Pack, Rule of Law Radio, and we're going to Doug in Ohio. Hello, Doug.
Good evening, Randy. How are you?
I am good. I don't care what everybody says.
Okay. I'm got a foreclosure. I'm in the appeal phase. And I just wanted to see what your thoughts might be based on a sequence of events I'll lay out for you. And so late last April, I put in, or that would be 15 months ago, I put in rescission notices, sent them out. And
wait, you put in what?
I sent out notices of rescission.
Oh, rescission. Okay. Hold on. When you sent out the notice of rescission, had you received a notice of acceleration?
Probably. I mean, I was already 3 years into the foreclosure action.
Oh, okay, good. Then you had received a notice of acceleration. Okay, good.
Yeah. Okay, so the trustee, the original lender went bankrupt in 2006, and that'll have significance here in a moment. So I got this letter from the CEO of the liquidating trustee saying as of 2006, the lender didn't, or 2007, they didn't have any loan on their books. Okay, so I put that letter and the fact that I had done rescission in a notice into the court. Okay, so about a week later, they rendered judgment for foreclosure for Wells Fargo. And
okay, hold on. Who was the original lender?
FMF Capital.
Okay, and that company went out of business in 2006?
2007.
2007. Okay, is there an assignment in the record prior to 2007 by the original lender to a third party?
No, there's not. The sole assignment was done in 2011.
Okay, did this company go out of business through bankruptcy?
Apparently, because I got a letter. That's who I sent the notice of rescission letter to, was the liquidating trustee company.
Okay.
For FMF Capital.
Is there a notice of assignment by the liquidating trustee notifying you of who the trustee assigned your mortgage to?
Never heard of them until we researched it and found out that who the trustee was. No, I got nothing from the trustee.
Okay, these are things that most people don't even think about. But okay, you got this company here, and this company has a set of assets, and it goes bankrupt. When it files for bankruptcy, it transfers all of its assets to the bankruptcy trustee. Now, if it's real property, then normally you would have to file notice of that with the clerk of the court, but with the county clerk. But if you only hold it 6 months or less, you don't have to make that filing. I'm sorry, 60 days or less. So he transfers all the assets to the liquidating trustee. And then the trustee will transfer those assets to some third party. Well, once the trustee takes possession, the trustee, if he transfers it to someone else, then he would have to file a assignment in the public record. So what this does is creates a logical conclusion that if the liquidating trustee didn't file that assignment in the record, then there's very good reason to believe that the lender who went out of business did not hold your note as an asset when it went out of business. But it also didn't file an assignment of that asset to someone else. So someone else has the asset, but they don't have an assignment of the security instrument. And when the original lender went out of business, without assigning that security instrument to somebody else, they abandoned it. That's the argument to make there. The other one is there an assignment in the record at all?
There's only one, like I said, that was done from FMF Capital through MERS as nominee.
Wait a minute. Hold on. You're getting a real bad distortion. Can you move the Mac down by your chin?
Yeah, I was on speaker also, so sorry about that.
Oh,
yeah.
Okay.
There's one single assignment. It was from FMF Capital through MERS as nominee to Wells Fargo.
Okay, FMF, was that the original lender?
Yes.
Okay.
Yes.
When was that assignment done?
2011.
Okay, I have a pretty basic question. FMF Capital was a person under law. Corporations and legal fictions are persons for the purpose of certain rights. Well, in 2007, that person died. So how did that person appoint MERS as an agent for that person? And how did that person direct MERS to transfer an asset of that person to some other party?
Yeah, I understand. And that's a point I'm bringing to bear in my appeal. That would have been impossible, I would think.
Yeah. Have you, in the suit, did you challenge the assignment as void?
Yes. Well, in the notice I put into the court, I did, yes.
Okay, good. Because if you hadn't, there is another tactic you can use, and that is to challenge the subject matter jurisdiction of the court.
Can I do that even at this point? I guess you can challenge subject matter jurisdiction anytime, correct?
Exactly. And what you say is that the alleged holder of the instrument does not properly hold the instrument and therefore lacks the legal capacity to bring a true controversy to the court, and thereby is unable to invoke the subject matter jurisdiction of the court. Now, you're not saying that the court does not have general jurisdiction over the subject matter, but that the court lacks competency to rule on the subject matter because the plaintiff is unable to bring a controversy before the court. Does that make sense?
Okay. Yes, it does. You know, it was interesting to me that the court didn't even acknowledge the rescission at all, just like it just ran right ahead and, went forward. And I put another notice in at the 20-day period for there to be any challenge to the rescission.
Try suing the judge.
Okay, and what kind of action? Civil?
No subject matter jurisdiction, no immunity of any kind.
That'll be a civil action?
Yeah.
Okay.
See, the only time you can sue a judge is when he acts without subject matter jurisdiction. And it makes no difference if you didn't challenge it. If he didn't have it, he did not have it. You can't grant him jurisdiction. You can't waive jurisdiction. If he didn't have it to start with, he never has it. He can never gain it. And when he acts without subject matter jurisdiction, you can sue him. We sued a judge in Austin over a credit card issue. I was helping a guy, and the lawyer filed suit, and there was an affidavit that was required to be filed with it, and they didn't file the affidavit. So a cursory look at the public record would demonstrate that this document was not there, a necessary requirement for the filing of the case. So we maintained that the plaintiff failed to meet the filing requirements and therefore did not invoke the subject matter jurisdiction of the court. And so we filed a challenge, and the judge comes into court, and this is just a JP in an eviction hearing. And the client said, "Well, Your Honor, what are you doing here?" I said, "You can't be here. I sued you." What? He'd never seen it. He went and got the case, and he's reading it and saying, oh my. And he finally said, "Mr. Edelman, it's not my place to determine jurisdiction. You have to do that." And he took instruction well. He said, "With all due respect, Your Honor, before you send me this summons ordering me to come to your court and telling me all of the things you're going to do to me if I don't, you need to make sure you have the authority to do that." And he said the judge just had the file in his hand and went back to reading it and walked out of the courtroom saying, oh my. So he got the county attorney to file an answer for him.
Uh-huh.
So we sued the county attorney for misappropriation of public funds. We sued that judge in his personal capacity. And he used a public servant to file his answer, so we sued the county attorney. Oh, that was great fun.
Wow.
Subject matter jurisdiction. That is their weakness.
Okay. Now, they also went ahead and ordered a sheriff's sale and went through with the sheriff's sale. Now, I had filed a suit before the sale as like an emergency thing to get an emergency stay. This guy helped me draw up a suit and put it in. Well, he dismissed it, but I did get a lis pendens recorded. And I also have recorded a mortgage lien from a trust I have against me. So they're just running right across that and ignoring all that. And I'm just thinking Wells Fargo can't even take possession of the property, even though I got an eviction notice today. So it just seems like they're heaping up, looking to get.
Okay. Now you file a challenge subject matter jurisdiction of the court, and you petition for a stay of execution.
Okay.
Now keep in mind, a higher court cannot restrict the eviction court judge. The eviction court judge has exclusive jurisdiction over eviction issues, but he can restrict the plaintiff. So be careful when you ask for a restraining order. Ask the court to restrain the plaintiff, not the prior court.
Okay.
It's an important detail.
Okay, so let me see if I got that right here. Going to break, huh? Okay.
And we got about 20 seconds. Yeah, okay. We'll go ahead and do the outro. This is Randy Kelton, Vet Pack, Real Bar Radio. A call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Vet Pack, Real Bar Radio, and we're talking to Doug in Ohio. Okay.
Yes.
I'm getting to where I'm getting pretty methodical with these issues, and it's because I'm thinking about them from a different perspective. Mostly people tend to think about these from what can I win in court? And over time in dealing with these, I've come to realize you can't win anything in court. The courts are going to rule against you out of hand at every turn, no matter what you do. Okay, I'm an engineer, so I don't do philosophy. I could say, oh, that's horrible, that's wrong, blah, 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 but that won't do any good. It is what it is. So how do we deal with it the way it is? How can I create a situation to where it's going to cost the guy on the other side more to fight me than to deal with me? That's always my perspective. You start kicking the judge in the seat of his pants. The lawyer has a bar card and you don't. The judge can't do anything to you. He's going to rule against you no matter what. So you don't care if he's upset at you. Who cares? You want to get mad, Judge? Knock yourself out. So I'll give you mad. I'll judicial conduct complaint you every time you turn around. And if you say one word to me about it, I'll charge you with obstruction or witness tampering. You can do that kind of stuff. So think in terms of how can I give the guy on the other side a good reason to want to make me go away? Doug, have you pulled all of the records from the county recorder's office and created a statement of facts based on those records to show how the chain of title doesn't fit together?
I have not. But
that should be the first thing you do. Now, I do these evaluations, but you don't need me. It's all really straightforward. You pull all those records and say, who's the lender? Okay, the original lender. How did the original lender transfer the property to the next person in line? I don't know the statute in Ohio, but I know you have one. In Texas, the statute is 13.001. And it says, any claim against real property not properly acknowledged or proven, acknowledged notary proven to witnesses, and filed in the public record is void as to the holder. And this is the point most lawyers miss, and most people who fight these things miss. In order for the public record to have any value, Ohio has to have that law. If I'm going to buy your property, Doug, I want to know if there's any claims against it. So I'm going to go look in the public record. And that's why they have it. If you don't file your claim in the public record, then I have a right to trust what I see there. If I don't see a claim, I buy your property, you come by 5 years later and say, hey, I've got this claim against this property. I'm going to tell you, go scratch. I bought this in good faith. There's no evidence of that claim, so you can't bring it. Every state's going to have that requirement. Otherwise, there's no reason to have a county recorder. So you got it. So always think in those terms. When I look in the public record, if I don't find a direct chain of title to this claimant, I don't care what you got. I don't care if you are, in fact, the bona fide, absolute, true holder of the note and security instrument. I don't care. If you don't have it filed in the public record, you can use that for toilet paper.
Randy,
okay.
I have Joe Esquivel's affidavit and security analysis in the record. So, and he's, I think, brought some of those points that you were mentioning to bear.
Yeah, but I have not found those securities analysis to be very valuable because primarily they go after securitization.
Right.
I don't care about securitization. The only time I care about securitization, I've had about three. This one, Wells Fargo was the original lender. Wells Fargo was the servicer the entire time, and Wells Fargo was the entity trying to foreclose. Now, I have a complete chain of title in the public record. I don't have anything. So now I want to know if Wells Fargo is in fact the holder, or did Wells Fargo sell that note to somebody else? That is the only time I care about a securitization audit.
Okay.
Otherwise, I don't care. I never bothered to get there because read Covenant 16. It's magic. The governing law and severability clause. In Covenant 16, both parties agree to abide by all relevant law. If I make a Hope-Atila respite claim, I never claim the remedy provided by the federal government. The remedy I claim is breach of contract, breach of Covenant 16. They failed to abide by all laws, therefore they repudiated the contract. Keeps me out of the federal court.
So should I gather all the facts from the public record, like you were saying, and write up a statement of facts and put that in as an exhibit to my petition to challenge subject matter jurisdiction? Is that how I should arrange?
Absolutely. Okay. And if you want me to, contact me by email. I can do the evaluation for you. But I charge for that because it generally takes me 2 or 3 days to go through all of these little pieces. And I find gems in there.
So do you want me to gather all this stuff up and send it to you as an attachment, or?
Yes, and this is how I would want it done. Mm-hmm. There's a universal dating system. And in the universal dating system, you use universal international dating system. You put the year, month, day, all in numbers. If you name your files, when I work with someone, I want them to put their last name, then year, month, day, and then what the file is. You drop that in a folder and open the folder, these will automatically order themselves in chronological order. I generally spend half my time when I do an evaluation getting all the documents in order. I have to open up each document and study the document to figure out what it is. And then I save the document as the name, and here's the date of the document. I put the date the document was filed in the record. And then I put, this is a deed of trust, lender, and amount. I'll put that in the title. And then there's an assignment. I'll put the date from, to, by. And that'll be by MERS or by the borrower. So that when it lines itself out, I can go right down that thing. And if there's a document missing, it will leap right out at you. And it's dramatically saved times. If you keep all your files of this nature done that way, I had a clinical psychologist, a friend of mine, that did his files that way. And I looked at his files and I said, that is absolutely incredible. It was so simple, but that's half of the evaluation. So if you order them that way, then I can go down them quickly. And I have a method for doing this. I open the document and I say, on this day, there was filed in the record a document titled as follows. And I go over to the document, capture out the title, and drop it in this document. The lender was defined, the borrower was defined as, I go capture it out of the document and put it in. So I never make a statement directly, make all the statements out of the documents themselves. It comes up a pretty compelling piece. First, I do statement of facts, where I cut and paste pieces of the documents, and then I go to a statement of factual accusation, and I refer up to those images that I put in, and show how they all fit together. It turns out to be a pretty serious piece of work. Hang on, we'll be right back.
Stroke. It's the third leading cause of death in the U.S. behind heart disease and cancer. Do you know the telltale signs? I'm Dr. Catherine Albrecht, and I'll be back with information that could save your life or the life of someone you love.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
A stroke occurs when part of your brain is deprived of oxygen because of a blocked or broken blood vessel. The brain will start to die unless you get fast emergency medical treatment, so it's important to know these warning signs. Sudden numbness or weakness of the face, arm, or leg, especially on one side of the body. Sudden confusion or trouble speaking and understanding. Sudden trouble seeing out of one or both eyes. Sudden trouble walking, dizziness, or loss of balance and coordination. And sudden severe headache with no known cause. If you or a loved one experiences any of these symptoms, call 911. Fast treatment saves lives. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see it too.
Okay, we are back. Randy Kelton, Vet Pat, Rootlaw Radio, and talking to Doug in Ohio. And Doug, I have Jay in Georgia, and I'm going to do something a little unconventional. I'm going to bring Jay up at the same time because both of you are kind of in the same place. Jay, are you there?
I am.
Okay, Jay, you have. What is your condition? Have you already been foreclosed on?
Yes, sir. My situation is a little bit different. This happened, and you're going to have to forgive me, this happened a while back. Numbers and things have been skewed in my brain, and I used to buy houses and pick them up and sell them, so they're kind of running together. But this was my personal residence. It happened about 2011. We did the foreclosure. It was originally owned by Countrywide. I sent them notice asking to produce the note and perfect a chain of title. They sent me back a letter that said, you'll like this. The answer to this question is beyond the scope of this request. We cannot provide this information for you. So they went ahead with the foreclosure. I filed a suit against them in Paulding, which is Paulding County, Georgia, which is a suburb of Atlanta. Filed a suit against them. They got their big-time law firm in Georgia to ask to have this, make a motion to have this thing transferred to federal court of Northern District of Georgia, which I objected to, but they did anyway, and then promptly motion to have it dismissed based on failure to state a claim that the release could be granted.
Okay, so and that was probably because you claimed fraud. Fraud is so hard to prove up. It's even really hard to allege properly. The last thing you want to do is claim fraud. You want to claim false and misleading instead of fraud. False and misleading will bring you under Rule 8 instead of 12. But with that under the bridge, have you done an evaluation of all the documents in the public record?
Are you talking about like a forensic loan audit?
Essentially, yeah, forensic loan audit. Not a securities analysis, but an analysis of all the documents filed in the public record from the perspective of any claim against real property not properly acknowledged or proven and filed in the record is void as to the holder.
Well, I did go look in the public record of my county to try and find the chain of title, and there was not one.
Okay. Who was the original lender?
The original lender, after, of course, the initializing lender, I would call him the very first one, and then they sent it to country.
I'm talking about who was the one that sat down at the closing table?
America's Home Lenders or something like that.
America's Home or America's Wholesale?
Might have been America's Home.
That's real important because American Wholesale lenders never existed.
Really?
They pretended to exist, but they never did. Okay. This is why I do these analyses, and this is the kind of thing I look for. You wouldn't believe the crazy stuff I find. I've got a new scam by J.P. Morgan Chase. J.P. Morgan Chase, I get this loan, and I pull all the records, and I forget who the original lender was, some funky little mortgage company. It went out of business. 12 years later, J.P. Morgan Chase files a notice of lost assignment. Now, J.P. Morgan Chase had nothing to do with this loan, but they filed this notice of lost assignment, and they said, we have a secure vault in Monroe, Louisiana. And I went through that secure vault in Monroe, Louisiana, looking for this assignment, and I could not find it. And then a week later, J.P. Morgan Chase files an assignment to somebody else. I found 2 of those so far. And I looked at that and said, what in the heck is going on? Who are you? And I've got one where the trustee did the trustee sale, but nowhere in the record is there an assignment, is there an appointment of the substitute trustee. There are so I never look at one to where I don't find at least a half a dozen claims. And I begin to believe that the banks sent us after MERS and showed me the note. It's like Briar Rabbit saying, oh, please don't throw me in that briar patch, because that's the easiest thing for them to fight. What they want above all is to keep you away from the public record and do not read the contract. Have you read the deed of trust?
Do I have the deed of trust? I'm sure I do.
No, have you read it?
Sure. Have I read the deed of trust for that particular property?
Yeah. If you read a Fannie Mae Freddie Mac uniform instrument, it don't make any sense. No reasonable person of ordinary prudence can make sense of it. It reads like the guy who wrote it was high on coke. If MERS is included in your note, what it says is that MERS is the beneficiary. So when MERS later does an assignment from the lender to somebody else, what does he assign? The lender don't hold anything. MERS does. It's right there in the contract. It says MERS is the beneficiary. Now, if I read that contract from the least sophisticated consumer perspective, I read that in the contract, I named MERS as the beneficiary, and the borrower accepted that. That's right. That's what it says. Oh, and then you go down further to second. After the definitions, you get the second paragraph there, together with paragraph that says, you understand that MERS is not the beneficiary, but merely holds legal title. Now, wait a minute. Trustee holds legal title. So you transferred legal title to the trustee in paragraph 1. Then you took it away from the trustee and gave it to MERS in paragraph 2. That means it's not a deed of trust, it's a mortgage. Who wrote this trash? It's unconscionable. I mean, it's too vague to be enforceable.
Well, where I am right now is this happened a few years ago. Luckily, I was able to do a little very, very rudimentary legal maneuvering and stay in the house for 4 years. I put the payments in my pocket instead, and luckily I was able to buy a house for cash right in the bottom of the trough.
Oh, so, man.
Things turned out halfway decent.
I want to reach through this microphone and hug you.
Well, I appreciate it.
I've got 2 guys that I've kept in their house for 7 years. And one of them, I had to file an action for him, a findings of fact and conclusions at law preparatory to an appeal. And I told him, this is a really big document. I want $1,000. He said, I don't have $1,000. Say what? You've been living in this $300,000 property for 7 years without paying a mortgage, and you don't have $1,000? Are you kidding me? It makes me nuts. So somebody who actually used this opportunity to save money, I am impressed.
Well, I mean, I was lucky, and I didn't save all of it, but I saved 90% of it and just got really lucky. But in my current situation, I'll just be straight out. I'd like to get a settlement. If there's not any, I would enjoy harassing them, but
okay, let's look at the public. Look at that record. And from the perspective of anybody who's trying to make a claim, they have to establish that claim by what's filed in the record. And now, you're an individual. You're not a lawyer. So you can do horrible, rotten things to them that lawyers can never do. Every time a lawyer files a pleading I don't like, I bar grieve him first. The second bar grievance, they're going to cancel his malpractice insurance. The first one, they're going to double it.
I've been hearing that. Okay.
Oh, that is such a big deal. I had Ken Magnuson on, but he dropped off. He'll tell you all about bar grievances. Hang on. About to break. Randy Kelton, Vet Pack. We'll be right back. Okay, we are back. Randy Kelton, Vet Pack Boulevard Radio, and we're talking to Doug and Jay. Doug and Jay, you're both kind of in the same position. Doug, what is it that you want to do at this point?
Well, based on what you said, I should probably get this motion or petition for challenging subject matter jurisdiction, correct?
Exactly. That will stop everything. Start this whole thing all over.
Okay.
And Jay, the reason I brought Jay in is because Jay's kind of in the same position. We look at the public record, and there's one other thing that I can give you. Wait a minute, Doug, did you filed a rescission, didn't you?
Yes.
Okay, that is a big deal. That's a whole different animal. Jay, did you ever file a notice of rescission?
No, all I did is, I'm post-foreclosure. You know that, right? It's the house is gone long.
Yeah. Both Doug is too, but Doug filed a rescission before foreclosure. If we can get the foreclosure thrown out, then the first thing you want to do is file a notice of rescission. But there's one other thing. When you were at closing, they put in front of you a HUD-1 settlement statement. And that HUD-1 settlement statement had all these fees on it. Did the lender provide documentation to show that the fees charged on the HUD-1 settlement statement were not otherwise forbidden to be charged by law, as some fees are considered to be part of the interest, part of the what's the term? The finance charge. And the finance charge is intended to be absorbed by the interest you pay. So that some of them were not otherwise forbidden to be charged by law, that the services were for services, the charges were services actually rendered, that the services were necessary, that the amounts charged were reasonable, and that the lender did not take an undisclosed markup on the amounts charged. That's all right out of the Real Estate Settlement Procedures Act. Did they give you any documentation to support those fees?
I don't know. Doug speaks.
Yeah, the answer is always no. They never bring any documentation. So what I claim is all of those fees are fraudulent, because they didn't support any of them. They're all fraudulent. And I run a analysis. I run a amortization of the note. And I do it on a spreadsheet, so it shows every payment. First payment, I take the full amount on the combination of lines 1401, I think it's C and D. The seller cost, buyer cost. Combine those together, subtract, because the buyer pays everything in the end. Anything the seller pays, he increases the amount he sells it for by that amount. So I take the full amount, subtract it from the first payment as an overpayment, and then run the note. First one I did was Steve Skidmore. He used to be a co-host on the show. $116,000 note at 6%. $12,000 on the HUD-1 settlement statement. We subtracted that from the first payment as an overpayment. His principal went to zero at payment 240. At payment 360, he overpaid the note $50,043. When you claim fraud, you do not claim the amount that you were actually defrauded of. This note was only 6 years old. You claimed the amount you would have been defrauded of had your loan ran to fruition. In this case, it would have been $50,043 and change. But you don't sue for that amount. You sue for triple. So on this calculation, I get a claim against the lender in an amount in excess of the original mortgage. After you get a notice of acceleration, you file a qualified written request claiming this as a accounting error. When they fail to prove it up, you file a rescission, and it's over. So if you can't file a rescission, then we sue them for this amount, this 3 times the amount that they would intended to defraud you of. Now you've got a big claim against them. And their problem is you can show how you got that claim to the penny. Now, they may disagree with it. They may argue with it, and they may try to whittle that amount down. But at the end of the day, the jury is only going to remember one number. And that's the number you walked in the door with. And it's not some number you pulled out of the air. $10 trillion. I had these morons call me when I was in North Carolina. They needed help. The feds were coming after them. They filed some liens against a public official. I said, well, what was the issue? Traffic. How much were the liens? $11 trillion. Guys, what were you thinking? They said, well, what do you think? I said, oh, you win the case. Oh, you think so? Oh, yeah, you'll win the case. But you won't miss the ride. You will lose your house. You'll lose everything you own. You'll probably lose your family. You'll probably spend a year or 2 in jail, and then they'll dismiss everything. Seen this happen before. How do you justify $11 trillion? When we sue, how do you justify this? And I'll show them how I got that number to the penny. And, oh, you say one of these fees are valid? Prove it up. We have never had a lender prove up one single fee. Never. Reason? If you prove up one and you don't prove up another, that creates an adverse inference. The inference that other fee is exactly what we said it was. Criminal fraud and theft. They always have bogus fees on the HUD-1 settlement statement. So that gives you another claim. I also compare the truth in lending statement to the note. And I almost always find a variance there. Generally, about 25% of the time, it's correct. The other 75%, you wind up, the truth in lending statement is the one they calculate your payments from. Right. And it's always more than what you agreed to pay on the note. So we add that in. I get an even higher number against them. And let them try to explain how they got these numbers. I think they just pull them out of the air. So we have a lot of claims we can bring against them. More claims than they can ever wade through. And then you get all the claims against them, and then you go to them and say, guys, let's make a deal.
Okay.
Does that make sense, guys?
Yes, sir. I like the sound of that.
Yeah. And main thing we want to do is go after contractual violations. Show me the note is a complex issue. You defaulted on the security instrument the day after you signed it. That's not a complex issue. You sold the note, but did not transfer the security instrument with the note. You transferred it to somebody else. You defaulted on the security instrument. Now, 10 years later, you accuse me of defaulting on it. You were already in default. Any violation of a covenant, they're in default. And they never follow law. So generally 15 and 16, they're required to give all notices by certified mail. When they sell these things back and forth in the pools, every time there's a change in beneficial interest in the note, they're required to file it with the public record, and they're required by the Real Estate Settlement Procedures Act to give you notice. When they don't give you notice, they violated law relating to the contract. They're in breach. This is really easy for the judge to wrap his head around. It does not involve anything to do with the feds. And if you can sue the trustee is always a state actor. You sue the trustee. If we sue the trustee for declaratory judgment, they remove it to the Fed. We immediately file challenge subject matter jurisdiction in the Fed. If the Fed doesn't remand it, then we sue the federal judge. And when you sue the federal judge, he is going to be really, really unhappy. But he can't say anything to you, so he's going to have to go get these lawyers on the other side by the throat and tell them, you do something to get this guy off my case, or I will destroy you. You'll never win your case simply because you have the law and the facts on your side. You'll win your case if you have the politics on your side, and all politics is local. And not all of it has to do with money. A lot of it has to do with a PO judge. And we can really torque the judge. That's my story, and I'm sticking to it. If you want me to do an evaluation for me, just send me an email, randy@ruleoflawradio.com. We'll talk off the air. Jay, I probably need, both of you, I really need to talk to you off the air because this is way too complex to get all done on this show. I would like to go through some more of this with you guys in detail, but we'll do that off the air. So if you send me an email, I'll send you my phone number and we can talk. But right now, we are out of time. This is Randy Kelton, Vet Pack, Rule of Law Radio. Thank you all for listening. We'll be back next week with Thursday and then again Friday. Make sure you listen. Thank you all for listening. Good night. Dangerous.